Thank you, Mr. President. I am Jeffrey Korn, a professor of law and the U.S. Army's former senior expert on the law of armed conflict, also known as international humanitarian law. I advised an independent commission task force under the auspices of JINSA in a 2014 assessment of the Gaza conflict. I commend the report's recognition that all parties to an armed conflict must implement and respect the law of armed conflict. While objective critiques of military operations can contribute substantially to the understanding, implementation, and evolution of the LOAC, finding and recommendations must derive from credible information, legal interpretation, and operational expertise. Otherwise, any critique risks distorting the essential balance between mitigating the suffering of armed conflict and the dictates of military necessity, a balance that has defined the law since its inception. I believe the report lacks this foundation. First, it treats questionable interpretations of this law as conclusive and fails to apply the principle of distinction comprehensively. Specifically, it omits assessments of how the enemy's systemic failure to distinguish himself from civilians and deliberate exploitation of the perception of civilian status impacts the reasonableness of attack judgments. Second, the report reflects a common but invalid tendency towards effects-based condemnations of targeting judgments. Combat effects are relevant when considering compliance with the LOAC, but cannot substitute for recreating the context of an attack decision to determine whether that decision was reasonable. Limited access to operational information may make this process difficult, but does not justify substituting effects as the touchstone of legality. Third, the report is not based on credible military operational expertise. This is exacerbated by the tactical context of close combat in an urban environment against an enemy deliberately refusing to comply with its distinction obligation under international law.